Your IEEE membership means access to insurance products featuring exclusive group rates, flexible benefit options, and portable coverage that stays with you throughout your career. Engineered to help protect your loved ones and your financial security. For more information, go to IEEEinsurance.com.
Hello everyone, and welcome to today's IEEE USA webinar, Contracts, Spreading the Risk and Avoiding Killer Contract Clauses. I'm your host, Jonathan Cho. We'd like to take this time to thank our sponsors for today's webinar, AMBA and the IEEE Member Group Insurance Program, for supporting today's webinar. Our presenters for today are Larry Borda and Daniel Lund of Phelps Dunbar LLP. Mr. Borda acts as a resource for insurance and construction clients, bringing unique insights gained from a diverse career in the insurance industry, the construction business, and as a construction litigator for 23 years. He spent 10 years in project management positions before starting his legal career. He also spent 14 years as an AE Focus Group head of claims for an international AEI insurer, where he directed the management of claims against architects and engineers working around the globe. He's experienced sitting on both sides of the table and brings this perspective to Phelps. Mr. Lund is in his element when he's standing in a courtroom. When clients have construction disputes that require litigation, they trust Mr. Lund and his 3 decades of experience to take the difficult cases to trial. Mr. Lund practices in the area of construction litigation with a focus on construction and surety litigation. He represents the design professionals, general contractors, major subcontractors, sureties, public and private owners, and wireless telecommunications carriers and owners of telecommunications infrastructure. Mr. Lund also serves nationwide as a construction mediator and as a construction arbitrator through Perry Dempf, and arbitrations only through the American Arbitration Association. Without further ado, I want to pass off to our presenters. Welcome, gentlemen. We're very excited for what you have in store for our audience today.
Thank you much,
Well,
Jonathan.
thank you, Jonathan. That's quite an introduction, Larry. I
As
was waiting
you
for
can
them to
see,
say that we were
collectively,
most in our element when
between
sitting
Dan
in a
and myself,
restaurant.
we have about 80
But
plus
I
or
tell you,
minus years of experience in construction litigation. So we've kind of seen it all and done it all. And our firm, which is comprised of over 400 lawyers, is spread out across the Gulf Coast, beginning in Texas and all through Florida. So I'm really looking forward to getting involved here today and helping your engineering participants in learning how to negotiate and draft contracts, which will hopefully leave them free to focus on their practice.
amen. I want to make sure that you all can hear me. Larry and Jonathan, can you hear me?
Yes, we can all hear you, Dan. Can you hear us?
Okay.
Folks, give us 1 second, just so we can make sure that Dan and Larry can both hear us. All right, Dan,
Can you
hear?
Can you hear me, Jonathan?
I've
Yes,
lost
we
it
can.
on my screen.
You can. Okay. I don't think Larry can hear me.
I see Dan's name. I do not see him.
All right. All right. I'm going to proceed. Folks, this program is geared to you all, engineers. A lot of what we present today is going to be applicable across the board in construction industry contracts, but we really wanted to focus on you all today and talk about risk transfer. So much of what goes on in contracts on the front end is not handled well, and I see it when I'm drafting contracts. I see it when I'm handed contracts after the fact. We think about assessing risk and reducing risk in our contractual work by doing really good work and by being really precise and trying to do a good job. But so much of the risk transfer can happen on the front end if you're careful in drafting your contracts. You can allocate risks in a way in a contract that you can't any other way during the course of the job. And it's one of the things we focus on today is why careful drafting is best for the parties on both sides of the agreement, not just one side. But you can allocate risks, define responsibilities, and protect the parties if you use the right language and pay close attention to what it is that you're doing when you draft your contracts. So what can you do with risk? A handful of things. You can avoid risk entirely, and that seems like, wow, that would be the greatest thing to do. But that's when two parties come together and say, look, we know that there's a risk here neither of us really feels comfortable with. Maybe we take that out of this contract and put it aside and let someone else handle that aspect that is a risk that they're better suited to handle. You can mitigate risk, reduce the possibility of risk to you by adding, for example, conditions before liability and responsibility attaches to you. You can transfer risk. We talk about this a lot in this program about shifting responsibility, not just for work and print, but more in the line of like liability and responsibility of legally to another party by careful contract clauses. And then you can accept the risk and you go, well, okay, I understand that, but what do you mean? Why is that important? I get so many contracts for review from clients who are disinclined to read the big 100-page contract and say, tell us what's in it. And I'll go to them and I'll say, this is a terrible provision for you. And they'll say, we can't negotiate out of that provision, but at least we know it's there. And they accept the risk. But you've got to know it's there, or else you go in blind and it can be problematic. So here are some key risk transfer clauses. The hold harmless and indemnity clause. You hear about that all the time. That is where you transfer liability that you might otherwise have to someone else for certain types of claims. The limitation of liability, and these first two, and actually all three of these first three, all have potential problems when we get into anti-indemnity statutes and what courts say about whether we can limit our liability this way or be held harmless for certain acts. But you can insert into limitation of liability clause which capture maximum exposure. Waiver of consequential damages, we'll get into in some detail. That's a super important clause that appeared on the scene in 1987 in the AIA documents, and no one knew it was there, it seemed. But you talk to folks now, they said that may be the most vital provision in your contract. Larry, can you handle the next two?
Sure. One clause that you probably heard of but not dealt with it very frequently is called the force majeure clauses. Those clauses are designed to excuse performance as a function of unforeseen events, things like acts of God or war, epidemics. Force majeure came into focus during the COVID epidemic, where contractors and others were using the COVID consequences as a basis for saying, hey, this is a circumstance beyond my control and unforeseen, which should excuse performance. It's come back recently with respect to the debate about tariffs and the impact that that has had on people's ability to maintain pricing and or supply chains. So it's just a concept that you should be generally familiar of. We'll talk later on about safety responsibilities, which are obviously very important. We'll also talk about, unfortunately, your ability to waive your site safety defenses in your contracts, and we'll talk about that in some more detail. But to get to Dan's point, all of these things can be controlled and addressed in your contract documents, and that's the time to control it. It's not to try and deal with an issue after it's arisen. It's to spend the time and effort necessary to draft your contracts carefully. Dan?
Thank you, Larry. And here is a provision that we talked today about provisions that are maybe a little bit counterintuitive, and this is one that when it hits you, and I know that in the design world, no damage for delay clauses are not prevalent. In other words, for designers, you don't see that as often as you do in regular construction contracts, although you would in a design build situation. But you have these set up where if someone is excusably delayed, let's say you're delayed in your work and it's not your fault, it's the owner's fault, you have a provision that says your sole remedy is to get an extension of time and no money, no damages. And the thing is, courts say these are absolutely enforceable unless that person who caused the damage was actually going out of their way. They call it sometimes active interference to stop you from getting your work done. As much as we don't see this in design agreements yet, owners love these. They put them in all their general contracts with contractors, and contractors put them in with their subs. if you're working in a chain of command, whether you're a sub-consultant or a consultant to an owner, and an owner says, you know what, I like that, I'm going to put that in there, it would be enforceable. So you've got to look out for the clauses like this, which seem very not even-handed, but which are enforceable against you.
So the beauty of that clause is that, again, it's a significant damage that you can address within your contractual agreement. And it also highlights the importance of knowing what's in your contract after you've executed it and making sure that you're adhering to the provisions. When you're trying to make a delay claim, for example, if you're impacted by a significant delay, there are typically notice requirements in your contract that you have to strictly adhere to. Otherwise, you're arguably going to be not entitled to claim that delay.
Right. So here is mutual waiver of consequential damages. As I mentioned, there was a gentleman, he's now in the insurance industry. I think he works for Gallagher. He used to be general counsel at Hunt, the people who build airports and stadiums. He said, as far as he's concerned, this is the most important clause you can have in your contract. And you may say, well, what's a consequential damage? And many contracts will define exactly what it is, and courts have done it as well. We're going to discuss some categories, but this is where both parties waive claims against each other for consequential damages. And what's interesting here is that the upstream party, let's say owner, and you're the designer, the owner is the one who is really waiving more, who has more potential for consequential damages than you. So let's take a look at this. When an owner waives their consequential damages, let's say they can't get their building open on time. They couldn't open in New Orleans for the Super Bowl and Mardi Gras. They may have rental expenses for every place they had to put all the furnishings that couldn't go in the hotel. They have lost profit. They have business and reputation losses because all those people who had reservations can't stay at the hotel. Lost income, financing costs on the loan that they continue to carry while all this is going on. Those are huge potential consequential damages that the owner waives. Now, the downstream party, and this would be true of a contractor, but it'd be true of a designer as well. What are your potential losses up for delay? Well, you may have some home office expenses. You may have your own financing loss or some business loss, but on balance, most of your damages that relate to your continued activity on the project during a delay are direct damages. Your personnel on site or your personnel directly on the task. And so most of your losses potentially are direct damages, and those aren't waived by this. This is why this is such a critical component for any contract, but particularly if you're the downstream party from an owner, to have this in your contract, a mutual waiver. And a lot of times you'll see owners saying, you waive them, but I don't waive them. Try to negotiate out of that. Larry?
Excuse me, as Dan mentioned before, one of the biggest provisions you're going to have to deal with in your practice are indemnity provisions, right? An indemnity provision is basically where you compensate another for their loss or fees incurred as a result of your negligence. And we often see it in the design professional context where the design professional is being asked to indemnify or compensate the other party for any costs and expenses arising out of negligence by the design professional. Now, it sounds kind of simple and logical to think in terms of, okay, if I've caused somebody a damage as a result of my failure, the law will dictate that the damages that are a result of that are something that other party can seek, right? But the fly is in the ointment in that when you get into the details of the language on indemnity provisions, you need to be very careful about what it is you're indemnifying for. Let's give some examples, right? If you say I'm indemnifying you for damages and expenses solely as a result of my negligence, that's a fairly narrow scope of indemnity obligation, right? If you say I'm going to indemnify you for any liability and expenses arising out of any of the acts or omissions that I've committed, think about that, arising out of. So what that basically is saying is that if you are any part of the chain in the genesis that resulted in the damages, you're potentially liable for the whole. Okay, So these kind of provisions are things that need to be reviewed by counsel. They are very state specific, meaning some states allow them, some states don't. And the bottom line is the narrower the indemnity obligation, the better off you're going to be. Be mindful of the state law and be mindful of the fact that if the indemnity is too broad, for example, if it is you who is getting the indemnification, then that's going to be narrowly construed because the states don't like to see engineers or architects indemnifying themselves away for their own negligence, right? They want the design professional to know they have skin in the game, that they're going to be responsible for the results of their actions.
And real quick, Larry, that just reminds me of that case we just saw from Massachusetts the other day, a 2025 case where the court said if you've contractually agreed to indemnify as a designer and there's a 6-year statute of repose, meaning at 6 years, there's no claim, no way, no how against the designer in Massachusetts law, but you have contracted this indemnity, we're going to extend it out for the contractual statute of limitations, which I think was 10 years. And this designer was on the hook for an additional period of time that otherwise wouldn't have existed had they not agreed to this. Now, I don't know if you can negotiate your way out of an indemnity provision entirely, but you got to know if that's happening. Among other things, you're going to have the insurance for that, in place all the way through the 10 years or whatever it is the state provides, but real serious.
So that particular case is well known throughout the design community. Many of the associations have filed amicus-friendly briefs with the court arguing why it's not a good result for an indemnity obligation to supersede a statute of repose. So I'm sure you'll be hearing more about that downstream. All right, another huge provision with respect to risk transfer is a limitation of liability, a designer of limitation of liability. And that's pretty simplistic. It basically says, as between you and the entity with whom you've contracted, we're going to agree to cap whatever I ultimately owe you, pick a number, $100,000, $1 million, whatever it is, or my fee, whichever is greater. All right. And the logic behind that is oftentimes the exposure you'll pick up vis-a-vis the services rendered doesn't bear a correlation, right? You think about it in the electrical world where the things that you do might have a semi-minimal fee, but a huge exposure. Same thing with geotech, small fees, big exposure. In order to help your practice survive and to protect your personal assets, you want to think about asking for a limitation of liability with the party with whom you're contracting. Now, there are potentials for these clauses to not be valid. Again, it could be deemed to be an anti-indemnity or an indemnity clause that's not allowed by the states, but that doesn't mean you don't try. And the other thing to keep mindful of is even though this is dealing with liability is between you and the person with whom you contracted, it doesn't affect third-party claims, for example, by workmen on the field or John Q. Public who get injured as a result of your services. Another form of these types of provisions is the designer limitation of liability, which is based on insurance proceeds, right? Where the limitation has a nexus to whatever liability insurance assets you have available once a claim is settled or judgment is finalized. And the logic behind that is twofold, right? Number one, the argument with the entity with whom you're contracting is, hey, I don't have assets. I'm not a manufacturer. I'm not an owner of buildings. I provide services. My only real asset is my professional liability insurance. So you offer that as a cap on whatever your exposure is to that entity, right? And the language we've offered here is one that says, since these policies are oftentimes reduced by defense costs, you're basically saying to the other side, whatever's left, when this case is ultimately settled or it's been adjudicated and finalized subject to appeal, these are the dollars that you're going to be entitled to. It's a dynamic clause. It's going to change depending on the nature of the policy. It's going to be subject to policy exclusions and deductibles, but it is seen a lot and it's used a lot and oftentimes is very effective.
Thank you, Larry. And here are some more protections. Mandatory arbitration consolidation. Construction contracts for years, starting in like 1900, all had arbitration as the default provision, and that changed in I think it was the 1997 version of the AIA forms, for example, as well as the consensus docs. But still, arbitration is a big deal, but it is contractual. And so when you have an agreement with party X that you've contracted with to arbitrate, if you're in court, you can bring in anybody who you think may be liable. But in arbitration, because it's contractual, if that party over there who you think may be liable to you for a claim against you, say it's a subconsultant, doesn't have an arbitration provision that not only requires arbitration but allows for consolidation, same thing upstream, you may not be able to get that party into that case with you, which means what? It means you may have two different arbitrations ongoing or two different proceedings with disparate results. So you want to try to make sure that your arbitration, consolidation, and joinder provisions are uniform up and down the chain of all the contracts that you're involved with. Pass-through provisions, liquidated damages are a lot like arbitration. They're contractual. And if you have a liquidated damage provision in your favor of your owner, let's say, and they enforce it against you, you can't just simply transfer those to somebody else without having a clause that deals with it. Obviously, we need tight time frames for everything that requires a time frame. The old saw was if you have a contract that doesn't have progress payments in it, when is the money due? And it's when the performance is fully complete. So obviously, anything that has a time component needs a clear time frame set forth. And then flow down clauses. You see so many contracts that say, we want to flow down all the provisions from the prime agreement down to subconsultant X. And the question is, do I have to do everything that the principal design consultant had to do, or just what pertains to me? And the answer is, you need to have a provision that says flow down applies only insofar as it actually pertains to your work. Larry?
So just kind of a review generally, and obviously you've got a competent broker to help you with this as part of your program, but there are many facets to insurance, right? And so on the one hand, you have contracts that allow you to transfer risk, and then you have insurance to pick up the risk when and if you've been unable to transfer it. So you're going to run the gamut from the GL exposure to help you with, your people getting into accidents or your vehicles getting into accidents. You're going to have workman's comp to protect your employees and yourselves in the event they're injured in the course and scope of their employment. There's builder's risk policies that the owner has to worry about it. And there are other programs that the owner and contractors will have that will insure them. So there's all kinds of insurance, all kinds of specialization. You really have to have a competent broker who's knowledgeable in the construction industry to navigate all of these different policies. So while you're limiting risk transfer, you just kind of need to keep some things in mind, right? As we mentioned before, when it comes to indemnity, especially if it's you who's getting the benefit of indemnity, that language may not be upheld by the courts. And conversely, if you're seeking indemnity, depending on who you're seeking it from in your contract, you may or may not be able to enforce it. But that doesn't mean you don't strive for the contract language that buttons down as best as possible what those indemnity obligations are, unless and until a court tells you that that language is not going to be invalid. Insolvent parties, oftentimes you're going to be dealing with subconsultants who cannot ultimately fulfill their obligations. You need to think about that in terms of making sure that, for example, there are not coverage gaps, right? Do I have insurances available from that subconsultant who's going to be able to meet their obligations, and in turn mine to the people with whom I contract? If I have an obligation which might amount to $10 million that I owe to an architect, I need to make sure I've got insurance in place for the subconsultant that covers me for that obligation, ideally, right? Or as much of it as possible, because you're also going to have deductible in issues, self-insured portions of that insurance that are going to have to come out of your pocket. Ideally, you want to have a subconsultant who's got that insurance, who's got proof of that insurance before you let them go ahead and do the work. And finally, talking a little bit about tender in an indemnification scenario, or perhaps even as a matter of law. If you determine that your subconsultant is primarily or solely responsible for what's going on, you may want to tender a claim to them under their policy and say, hey, this is you, defend me, acknowledge I'm going to be protected by your policy, and you're going to cover the liability. Some of the problems you get into with that are kind of a boomerang effect, where if your language is not tight, you're in danger of having that claim come back to you in another fashion. It's the same logic that comes into play when you're thinking or contemplating about bringing a fee claim for your work that you've not been paid, right? It happens all the time. You've done the work, you build it, you've not been paid. All right, I'm owed $10,000. Do I want to bring that fee claim? Realize that many, many times, I don't know if I could say the majority, but certainly a substantive number of times when that is done, you're going to get hit with a counterclaim for professional negligence. That's just going to be a knee jerk. It's going to be recommended by counsel for the other side, and the owner will oftentimes buy into, either as a basis for negating your claim or for putting money in their pocket. All right. Is this mine, Dan?
Yes, sir.
Okay. So the key to what we're telling you is that if you can keep these contractual provisions in mind, all right, the limitations of liability, the indemnifications, clarifying scope, and we'll talk about scope later on, which is very important. You're going to reduce the number of claims that you're subjected to. When you are subject to the claims, you're going to reduce your exposure. You're going to reduce your damages. Okay, that in turn is going to mean that you're going to have a cleaner record when the insurance company comes to look at you and determine your insurability and then your rates. So your premiums will be lower, your deductibles will be lower. You're going to have more timely resolution of claims, because the scope of the claims and the ability to seek damages for those is going to be narrowed by your contractual provisions. And ultimately, you're going to have more time to focus on that which you know how to do, which is the core business of electrical engineering.
Thank you, Larry. We get now into what I will call mechanics regarding contracts. When a contract is signed, a lot of things happen. One of the things that happens is this. You're looking at the slide I'm looking at. It's a bunch of people partying. Everyone gets excited about a contract. They get so excited that maybe in the process of all of it, they haven't paid close enough attention to the contract. They were more excited about the prospect of the work and figured the contract would work itself out. And then, though, they put pen to paper, they sign the contract, and the contract goes into the vault. You have to remember that a contract, especially in construction, where it's typically a complex contract, is an open book test. And it not only needs to be reviewed every time there's even a remotely a question on what the contract says and what we're to do, but it also, and we get into the mechanics here and the nuts and bolts of clear drafting. If it's hard to administer, having it open sometimes doesn't make it any easier to figure out what it means. But one thing that can't happen is the contract can't be relegated to a cabinet somewhere or a file on a computer and never opened again during the job if a question comes up. But maybe even more importantly than all of that is this. Contract drafting, it is astonishing to me when I get contracts, including from giant companies, that are just terribly written. They are sometimes put together by several individuals over time. They cobbled together. Well, this one worked well, and this one worked well, and we pushed them together, and they don't work well at all. Contract drafting requires real due diligence, and this is why. Contracts have the effect of law between the parties. I ask people, I teach a lot of construction law seminars, and I'll ask early on in the seminar for people to raise their hand. Who knows anything about construction law? And somebody will say, well, I know something about lien law. 98%, and maybe that's an understatement, of construction law is what's in the contract between the parties. Every state has a rule that says parties are free to contract that anything that they can do legally. In other words, if it's against public policy, and some of this indemnity language we're talking about being against public policy, that's pretty rare. Just in the same way that that no damage for delay clause is not against public policy, most of what you put in your contracts is legal, and that's where the parties make the law between them. And there's no extraneous thing to review for the law between the parties other than the contract itself. So interestingly, that picture we had with all the people partying leads to the conclusion sometimes among folks, hey, let's just draft a simple contract because we're friends right now. And why can't we draft a happy contract? The problem is that contracts are set up to address, among other things, when things go wrong on the contract. Larry provided this graphic of some crazy salaries of players. Larry, Brian Kelly, he's not on that list because he's not a player, but the coach from LSU had a great contract drafted. When things went wrong, he gets $55 million to walk out.
So the moral of the story is contracts are not designed to address when things are going well, right? It's kind of like a prenuptial agreement. They're designed to address when things go bad. And unfortunately, when you're going into the project and you're feeling kumbaya and everybody's happy, that's great. You get into that laziness sphere that Dan talked about. But you got to be vigilant. You have to realize that these contracts are being drafted for when things go bad, right? Was Dak Prescott's contract the bad one? I don't know. Based on how he played against my Eagles a few weeks ago, I'm not so sure. But the moral of the story is there's going to be things, especially that happen on a complicated contract project, that are going to go wrong, and you want to have the guardrails set up with your contracts to help protect you.
Yeah, so the word that's missing after the ellipsis up there is the word breach. You draft your contracts assuming that they will be breached, and so that you can address what happens when a party breaches. Now, you get into the point of let's draft the contract. You got two principal types of contract. A contract of adhesion is like that little kid there ripping the Band-Aid off. Somebody who is a party with unusually strong bargaining power, like a large company or governmental entity, comes to you and says, I want to contract with you, but here's my form and you'll take it or leave it. And that's a contract of adhesion. On the other end of the spectrum is the negotiated contract, where everybody is weighing in and we're trying to make it fair and we're revising. Frankly, every contract is somewhere in between these two, because invariably we start with somebody's form and they're dialed in and hell-bent on certain provisions remaining in place. You just need to know where the rough patches are and where the negotiated terms are, and try to get rid of anything that is just a terrible term for you that the other side is stuck on. And if they can't get rid of it, decide if you're going to take the job or at least acknowledge the risk. But you see those contracts, right? Behemoth Corporation X says, here's my contract, and it is one-sided. Every clause in there says you, not me. And is that the best contract for everybody concerned? And the answer is probably not. And here's why. Even-handed contracts are better for the job. For example, if you're a designer and the risk allocation says this, it says, if the low bid exceeds the budget, the designer shall redesign the project to bring it within budget at no additional compensation. Well, I don't know how much that entails, but that's a crazy imposition on the designer unless the designer had that built into the price. Or how about the designer assumes full responsibility for all the subsurface conditions and utility locations, regardless of what the owner provides as data? That's awful. Both of those are not only unfair on their face, but they may hurt the overall project, and that hurts the owner. So the owner who pushes that down on you, or the contractor who pushes that down on you, is hurting themselves in the process. Same thing with administrative costs. If there are crazy reporting requirements or other administrative hurdles that you as the contracting party has to go through that are really unnecessary, well, that just increases your administration expenses and takes your focus off the job. It's not good for the project. How about if you have claims procedures? You see these. You've got to report within 24 hours the facts surrounding a known claim, and give us enough detail and the price that we can. Who can do that? And if you've got that, that puts you sort of in claims mode constantly on the job. You don't want that. It's bad for the whole job. So we want to draft a contract that's clear and simple. And you say, Mr. Lund, that's obvious. But how often do you actually see a clearly written construction contract? I'm going to say not that often. And here's what's important. And you want your contract to be clear, because when a contract is in front of a judge or an arbitrator, and arbitrators have some latitude, but they're supposed to be doing the same thing as a judge. When the words are clear and explicit and don't lead to absurd circumstances, like it doesn't say build a building upside down, no further interpretation may be made in search of the party's intent. So one party says, well, that's not what we meant. But if the contract says A, B, C, X, Y, Z, the court says that's the law between the parties. I'm not going to listen to what you say about it. I'm not going to listen to what you say. That's what it is. And that's how, and you want that. If you've carefully drafted the contract, you want that to be what comes out of it. Now, the alternative is with the parole evidence rule. If something's unclear, courts or arbitrators say, we'll allow testimony and we'll allow some extraneous facts to come in to help us figure out what the contract means. But ultimately, we're going to decide, we, the judge or the jury or the arbitrator, are going to decide what your contract means, which entails that you drafted this contract and you don't really have any say-so in what it means. Somebody else is going to tell you what it means. You don't want that. All right. So how about this rule of thumb? If there's a doubt in a contract, if the court throws up its hand and says, I can't figure it out, but you furnish the text, so I'm going to hold this provision against you. And I ask the room, do you want to be the party then that drafts the contract? And more often than not, the quick reaction is, heck no, I don't want to be in that position. And the answer is, of course, you want to be the drafter. You want to be in control of the document. We're going to talk a little bit about version control. You want to be in control of the computer, the form, the process. You want the other side to feed you their proposed changes, and you figure out how you're going to put them in. And in doing that, you can ensure that you get the best contract for you and really for everyone, but ensure that someone on the other side is not sloppy. You do a good job. You want to be in control of the contract.
So the mantra that I come back to here is, and it happens so many times when I reviewed contracts, either before litigation or once litigation has commenced, is I look at the language and I say to myself, what does that mean? Right? And if I can't answer that clearly in my own mind, if I'm hesitating, if I'm wondering, if there are nebulous statements that are difficult to define, those are the kind of things you want to stay away from, right? And just think about that when you're thinking about, especially your scope. And I think Dan will talk about this later. It's why defining your scope is so important, because that's the language that's going to measure what your duties and responsibilities are. So you want to be very super clear in simplistic terms, mutually understandable terms to yourselves and the contracts and others as to what it is you're contracting for.
Amen. Some pitfalls, bad drafting. I thought about this. I'm a fan of AI. Can AI help here? You know, if you have a bad clause, you could take that and put it in AI and say, AI, I'm trying to get across here this point. This is what I have now. Make it better. Yes, I think AI is a perfect solution for something like that if you're just having writer's block for a term. Complex terminology, you get sentences that have complex clauses embedded in the middle of them with all sorts of terms and conditions in a single sentence. It's impossible to figure out the meaning of the sentence. Or how about these excessive cross-references with defined terms where we got the term work and it's capitalized and indemnified parties, and then later work's not capitalized and claim is capitalized, and then it's not. Who knows what any of that means? You've got to make sure that if you're going to have defined terms, there's consistency, and you can always connect the dots. And then document control issues. This I thought was going to go away, and it's just gotten crazier. Back in the day when Larry and I were still in grade school, I guess, when computers came out, and you generate a Word document or a WordPerfect document that looked just like an AIA document. boy, that was a document control problem because there's a clause in there that I know is not in the AIA document. Let's say like a pay if paid clause. And you'd say, well, how do I know that this is a real problem for me? I got to go through this with a fine tooth comb to find out where you've changed provisions. So now all the document platforms, I can say AIA and Consensus Docs, all have document control features where if you get a revised document, for example, with the AIA, you get a additions and deletions report. Well, I don't get those sometimes. Well, I see that. I know that that's a problem. You got to make sure that you understand how those work so that you know that when someone's not following the rules or the protocols, you need to call them on it and say, let's get back to following those rules. Also, of course, document control, if we're just bandying back and forth a Word document, let's say it's not a standard form, who's in charge of that? You send it from here over here, they edit it, you send it over here. What document is the final document? You want one person in charge of that, if at all possible, like we said earlier, have the other side feed their proposed changes and have that one person be the keeper of the cookie jar on that. Some other pitfalls, repetition. You see people, because they think a concept is important, repeat the concept over and over in the agreement. The problem is every time they repeated it, they added a word or changed a word. Confusion, get rid of it. Crazy long sentences and paragraphs. How often have you seen an entire page be a single paragraph? You physically, mentally cannot read that. Break it up. And too many moving parts, you get a principal contract, terms and conditions, supplemental conditions, addendum, too many moving parts. Keep it down to 2 or 3 moving parts, even on a big contract, or else you can't manage, you can't open the book and read the book when you need to decide what's coming up next for the contract. How do we interpret contracts? General meaning. Words are giving their generally prevailing meaning in common usage. So what do courts refer to? Webster's dictionary. Like Larry said, if you see a word and you don't understand it, say something. Same thing with technical words giving their technical meaning. Again, don't feel like you can't say, I should know that technical term and I don't understand it. I'm just going to ignore it. Ask the question. Incorporation by reference, this has changed over the years because it used to be that we'd get a roll of plans and a book of specs and we'd mark the pages and I don't think we do that anymore. And I think it's probably changing on a daily basis, but identifying, making sure that we know exactly which shop drawings, which set of plans, which set of specs are pertinent as of the day we sign the contract and as we move forward is critical to ensuring that we've got the right stuff in front of us. We had a case, this is probably 30 years ago, but the Lakefront Arena at the University of New Orleans, it's a 10,000 seat arena. It looks a little like the Superdome, and it's got sloped metal decking around the side. And the metal decking had fireproofing sprayed on the underside. And when people would open the doors to go in the arena, the metal decking would flex and go waka, waka, waka. And the spray on fireproofing fell on everyone's head. And the question was, why did that happen? Well, we have a shop drawing that shows mechanical fastening for the spray on fireproofing. Well, that wasn't done. We have another shop drawing that says use glue. Well, there was an addendum to it that says use glue. That wasn't done. Eventually, nobody really knew what was the right shop drawing. That was a big multi-million-dollar case just because we didn't identify the drawings correctly and attach them to the agreement.
So two issues here. Number one, specificity when you are incorporating, and secondly, and I forget, Dan, if we talked about it later on, but you just really have to be mindful about getting tripped up on incorporation by reference clauses in your agreements, because oftentimes, especially for a sub-consultant, the prime will try to incorporate its obligations vis-a-vis the owner or the design builder and lump you in with that. And now you've bought into a whole nother set of duties and obligations, which might require a whole nother examination of what's in there, what's inconsistent, what's added to in terms of your obligations. So something to really, really be careful about.
And in similar concept here, this contract documents, you see every contract says, here are the contract documents. And they enumerate a lot of things. And it becomes a lot of documents. And I get it. You're everything down to architect supplemental instructions and RFIs and all these change orders all become contract documents. It's appropriate. you got to know what they are. You got to have a list that's appropriate to the job. You've also got to avoid attaching things as contract documents that shouldn't be. For example, you're an engineer and you have a proposal and you've provided it, and they say we're going to put your proposal as part of the contract documents. Well, is that a good idea? Probably not, because your proposal has terms and conditions that you may have wanted, but which aren't part of the contract, and now there's a conflict. So better to incorporate what was in your proposal that's important in the actual contract and leave the proposal aside. However you do it, you need also to have a hierarchy stated in your contract that says, look, if we have a conflict between document A and document B, well, then document A primes that, and you have a whole hierarchy of documents that way. And then this idea of changes, you say, well, that's simple enough. But you'd be surprised how many change provisions are so thin in substance and don't cover how are we going to get paid, how are we going to evaluate what gets paid. We end up in a fight over every change, and it eventually becomes essentially force account work, and we have this lingering battle over whether the change work was required or not. You definitely have good change provisions in your agreement. Larry?
And the other important thing to note, and it harkens back to what Dan said about, once you sign the contract, sticking in a vault and forgetting about it. A lot of entities will have contract administrators who kind of separate themselves from the project management side and are watchful about the contract and the contract's requirements so that they stay up to speed on the notice requirements and doing those things that you need to do so as to not waive your rights. And that is something as a risk management tool you ought to consider. All right, let's talk a little bit about standard of care. We all know what standard of care, right? Standard of care is the process by which you are judged in terms of whether or not you have fulfilled your professional responsibilities, and is codified not codified, but is memorialized in the AIA documents and other platforms. It's basically you're judged by the standard of what someone else similarly placed in your community would have done were they in your shoes. Perhaps what's more important in today's day and age is what is the standard of care not, okay? The standard of care should not be that you are the best person in the industry for doing this work. The standard should not be that your work will be first class. And I come back to what I talked about before. If you don't know what that language means, why are you agreeing to it? Why are you agreeing to be an expert at designing facilities of this type? What does that mean that you are an expert? Right? Does that mean that you're better than most of the other engineers who are employed to do that work? And what you're doing by the farther away you get from the standard of care as dictated by something similar to the AIA documents, the more you get into trouble because you're expanding the universe of what your duties and obligations are. You're expanding the field of experts who can critique what it is you do and how you do it. And the main thing you don't want to get into is to raise your obligation to the level of a warranty. You don't want to have a performance guarantee where you say, for example, I'm going to limit my RFIs to a certain number. I'm going to limit change orders to a certain number. Because now you've taken yourself out of the realm of standard of care and you've created a warranty which has a definitive identification of what constitutes a breach. And that not only gives you issues because you don't have the protection of what others in your community would have done, but you've also got potentially exposures as a function of your insurance carrier not insuring you for that exposure, because insurance companies do not insure warranties or guarantees. They insure performance within a standard of care. So we talked a little bit before about safety obligations, and as you also probably know, that the industry has done a really good job, or the profession, I should say, has done a really good job of memorializing in contract documents the fact that the designers and designer personnel are not responsible for safety, right? The documents are replete with identification of safety being responsibility of others, means and methods being the responsibility of others, periodic observations not amounting to supervision of the work. Nonetheless, that language having been in place for decades, the plaintiff's bar is always nipping at the edges, trying to figure out how they're going to overcome that type of language because they're often faced with bodily injury claims that are caused by the plaintiff's employer, right? So when somebody's injured on the site, be it a carpenter or a plumber, normally his recourse is going to be against his employer because typically it is they who are the ones that cause the damages primarily. So the plaintiff's bar will look around and say, oh, I see an architect or engineer here on the project. Maybe I can tag in with it, especially if I can tug at the heartstrings of the court by saying, hey, this designer, this engineer, this electrical person walked past an obviously dangerous situation, knew it was dangerous or should have known it was dangerous, did not do anything about it. In those situations, the plaintiff's bar is hoping that the courts will turn a blind eye to the contracts and feel sorry for these plaintiffs and figure out a way to give them relief. In this case, at the trial court level, where a fellow injured himself while doing demolition work and doing it stupidly at the instruction of his supervisor, the architect was sued. Trial court said, contract's very clear, it's replete with all of the things I've just discussed. There is no liability, go away. That was taken to the appellate level and appeal court. That court reversed, surprisingly, and found a basis on which there was some duty that had been volunteered for or should have been volunteered for by the design professional by virtue of seeing an obvious risk. Fortunately, in this instance, after I'm sure many years and many, many dollars, the Supreme Court ultimately decided that the contract terms were clear, that weekly site visits required to ensure the work was progressing per specifications was not to be construed as supervision, and therefore site safety and construction methods remain allocated to the contractor where they should be, and that's where it stood. But all of this just reminds us that when we're on the field, we've got to be really careful about doing things that take us beyond what our contractual duties and responsibilities are, right? Because once you step out from behind the shield of your contract, you're now in what I call volunteer world, right? You're volunteering yourself for duties and obligations you're not contractually obligated for. It opens up a whole Pandora's box of possibilities for problems. So you want to be very careful. If you do come into a situation like that, you want to go back to those who are responsible for site safety and means and methods and say to them, hey, I saw something over here. I think it's questionable. It's your job. You need to go over and address it. And ideally, you should memorialize that conversation after the fact because, as we always say, if it's not in writing, it didn't happen.
And Larry, what's fascinating is that architect didn't say something, which he probably should have. And I know he said, I don't want to, it's not my business or whatever. But just, I'm holding up, I hope you can see this. I copied out of that case all of the provisions that said site safety is not the architect's responsibility. And it took all the way up to the Louisiana Supreme Court, 3 court decisions to get to the point of saying, oh, yeah, that's what it says. So this food for thought, got to draft those really strongly. All right. Just briefly, top causes of construction claims, whether you're a contractor or a design professional, scope changes, unforeseen physical site conditions, design issues, workmanship deficiency. Is it from the workmanship or is it from design? Poor management, site access, all these things, all of these causes can be addressed in appropriate contract clauses and ought to be considered. If you see a really short construction contract or a design contract, beware, because these days you're putting yourself in harm's way and not having enough there to shift that risk out to somebody else or to define it suitably for yourself. If you are faced with claims and disputes, you really need to have in your agreement appropriate claim and dispute resolution provisions. Number one, notice. And notice isn't just to say, I want the claim process to come to an end. It's to say, if you have a claim against me, you need to give me some notice early on so that I can potentially address this. If I'm damaging you, I want to be able to maybe stop damaging you. You got to let me know. What are the documentation standards? We're going to talk about that in just a second. But what needs to be provided in order to sufficiently show that a claim exists along with the notice? what law applies. Some states like this one, Louisiana, says if you're in Louisiana on a project and one of the contracting parties is a Louisiana citizen, you can't apply any other state's law. But if it's a citizen from Alaska and Hawaii here, they can apply any law they want. Well, it matters because these states' laws, as Larry said, vary differently in all sorts of things, including indemnity obligations. You need to know what that is. And then dispute resolution processes. I mentioned arbitration earlier. Has anyone ever used a standing project neutral on a job? We've done it, and it's amazing. You get someone in who's like an arbitrator to sit with the job for the life of the job and to rule on disputes. I know that the AIA has that IDM, the initial decision maker aspect of its agreement. The AIA finally had to put in a provision in the last revision that said, by the way, the IDM has to be neutral and not show favor to anybody, because nobody believed that the architect was going to be even-handed with his approach because he works for the owner. But anyway, this project neutral can really be that neutral party that sits there and is familiar with the project and can not only rule quickly but also consistently based upon actual knowledge of the process. Uh, do you have mandatory mediation? Mediation is a voluntary process. So how can you force someone to sit down and negotiate in good faith? Well, you really can't, but fact of the matter is if you require them to sit there for a day, eventually cooler heads tend to prevail. And mandatory mediation, well, empirically it works. And do you want arbitration or litigation? That depends upon the circumstances of your case. Arbitration is typically my preferred method because you get an arbitrator who understands construction in a construction case, whereas many judges, we used to say juries didn't like construction. I don't think judges do either. Arbitrators are well suited to the task. If you are in that claim, you've got to, well, let me just say, we haven't said it before in this, but very often in these seminars, we say if you get nothing else out of this seminar, the most important thing that you can get is document everything. Everything you do on a project of substance should be in writing, and if it needed to be transmitted to someone, transmit it. But at the commencement of the job, you got to make sure that these documents, contracts, notices, schedule of values are all in place, because otherwise, who's going to be able to say what went wrong and how it affected the job if we don't have all of that? And then during the project, meeting minutes, daily reports, RFIs, responses, all those things need to be in place in order to ensure that if a claim is raised, everyone's in a position, and certainly you, to defend against it or to prosecute it, whatever position you're in. We conclude now, contracts, not how you do your work, not anything else, but contracts are the primary method for transferring risk in a construction project. If you allocate the risks, define the responsibilities, and you're careful with your contracts, you reduce your claims, your exposure, and your damages. You lower your insurance, you lower your deductibles. As Larry said, you have a much better record. You can speed up your claim resolution, and you can do what you do best, which is focus on your business. We have a few minutes left for questions. I know that the folks who are hosting the show are fielding questions. If you have questions now, you can submit those, I believe. And here's contact information for Larry and me for the folks at AMBA and IEEE. We really appreciate this opportunity today. And for the rest of the time and thereafter, we're available to answer any questions that any of you may have.
Fantastic. Thank you so much, Dan and Larry. So, folks, I know
Jonathan, anything in the chat we need to talk about?
Yes. So, folks, I know we're just about out of time. We'll get to just a couple audience member questions before we close things off. So, Dan and Larry, first question from our audience members. Can you briefly explain how the OCIP insurance program works?
Dan?
I'll let Larry. It's an owner-controlled insurance program, and there's also a CCIP that is a contractor-controlled insurance program. And basically, and I don't do a ton of that work, but you've got to enroll in it as a participant in the project, and it allows you to gain the benefit of that coverage. But there are nuances to it and requirements that have to be met in order to be a part of that big insurance package for the project.
Yeah, they are large and complicated. It usually requires a fairly large project to finance it. In addition, on the larger projects, especially the capital infrastructure projects, we're seeing design builders carrying design professional liability coverage, both to the extent that they're directly engaged in designing and or, if the architect or engineer is subbed out to the design builder, they want to make sure they've got coverage over and above what the designer might be offering to cover their obligations to the owner or to the design builder.
Great, thank you. And so this final question that we'll go to, audience member asks, how does professional service liability work if the designer leaves the consulting firm before the project is not complete, or before the project is complete, in case there is error found in design after the designer left?
I'm reading that
You
question.
kind of came out. You kind of came in and out on that. Give it to me one more time, please.
Yeah, absolutely. Let me just read over what was exactly asked. How does the professional service liability work if the designer leaves the consulting firm before the project? I'm guessing meant to say before the project is complete,
Yeah,
in case there is an error found in the design after the designer leaves.
yeah,
Well, a couple of things. One, I mean, the design firm maintains liability for the design, but the individual designer, and I guess this would depend on state to state, but in most states, I believe it would be the case that the individual designer is also responsible in negligence. And no matter where they go, as long as it was them, that individual who committed the negligence, they would still be on the hook individually. They may be covered by that policy. It would depend on the policy. Most design errors and omission policy are claims made and not occurrence policy. So I don't know how the nuance there would apply, but um, they certainly would still be on the hook for that.
right. So typically, the design the professional liability policy will cover the employer and will cover any employees who did work for that employer. Right now, the thing you have to be a little wary of is that as a designer who has sealed the documents, you've got independent duties and obligations as a function of that sealing, which will also carry liability with you. But again, all of that liability should be covered within the professional liability policy carried by your employer. And if you have questions on that, you should ask your employer and get that clarified.
Great, thank you both so much. So, folks, unfortunately, we are out of time. I know we received a lot of really great questions from our audience members. Luckily, our presenters have provided their contact information on the screen in front of you. So, if you do need any specific questions, please be sure to reach out to them to get a direct consultation as well as advice. Gentlemen, thank you both so much for joining us today and for sharing your valuable insights. You've both been fantastic to have.
Thank you very much. Our pleasure. It's an honor.
And thank you to our audience for tuning in and for your great questions as well. A few announcements before we close things off today. First up, clear your calendars and get ready for an event like you've never experienced before. In October 2026, the inaugural IEEE USA Big Thinkers Conference will bring together the brightest minds from across a wide range of industries and disciplines to accelerate the professional growth and leadership skills of early and mid-career professionals. Sign up for email updates through the link provided. Next up, in case you missed the announcement, IEEE USA's cruising saga continues in 2026 back to the Bahamas. IEEE USA will be hosting a 4-day Bahamas cruise October 5 through 9, 2026. We'll be cruising in style aboard the Carnival Glory from Port Canaveral, Orlando to Nassau, and then to Celebration Key before concluding our cruise back in Florida. Finally, we'd like to extend a heartfelt thank you to our webinar sponsors, AMBA and the IEEE Member Group Insurance Program, for making today's session possible. Their ongoing support empowers IEEE members to take charge of their financial well-being through exclusive, high-quality insurance options tailored to professional needs. Whether you're just starting out or planning for the future, their offerings are designed to help you build a more secure foundation. Be sure to explore all the benefits available to you as an IEEE member. If you enjoyed the content presented in today's webinar, please be sure to check out our extensive catalog of other presentations and publications available on demand on our website for your viewing pleasure. And if you haven't yet, please be sure to like and subscribe to our IEEE USA social media channels. And don't forget to check back daily for updates on upcoming events. Have a great day, everyone.
Your IEEE membership means access to insurance products featuring exclusive group rates, flexible benefit options, and portable coverage that stays with you throughout your career. Engineered to help protect your loved ones and your financial security. For more information, go to IEEEinsurance.com.